Fiat justitia ruat caelum. Let justice be done, though the heavens fall. Hello and welcome to LicitElite. At LicitElite, we make you learn law in an easy peasy way. Friends, today I will introduce Indian Penal Code 1860. Being the most unique and amazing penal law, the Indian Penal Code entails a number of crimes, their scope, nature, and their punishments. It is of utmost importance for law students, law learners, legal practitioners, and judiciary. Jeremy Bentham, a well-known jurist on the subject of law reforms, indirectly contributed much to Indian Penal Code. This substantive law code is much influenced by the British law. However, it also derived some elements from Napoleonic Code 1804, Virginia Civil Code 1825. The Indian Penal Code has been considered as an appropriately drafted code, relatively revolutionary. Friends, it has appreciably survived for 160 years in a number of jurisdictions without major corrections or amendments and is still on. Indian Penal Code was enacted in 1860. It stands as a tribute to John Macaulay, who acted as the president of First Indian Law Commission, which was constituted in 1834. John Macaulay has said it very well. Our principle is simply this: uniformity when you can have it, diversity when you must have it, but in all cases, certainty. The Indian Penal Code is a role model in the matter of certainty. During the 143 years of its existence on the statute book, it has undergone the last number of amendments. Indeed, rarely one come across any judgment stressing the need to fill in any lacuna in the Indian Penal Code due to the ambiguous language or otherwise. Let us talk about the past, the history of Indian Penal Code. In ancient time, there were no criminal law. A man could attack anyone at any time. You know, friends, a tooth for tooth, an eye for an eye, or a life for a life was the rule. The advancement in time made a man to agree upon accepting the compensation instead of killing his opponent. There came the existence of a sliding scale for satisfying the ordinary offences which gave birth to an archaic criminal law. The history of criminal law can be better understood by going through the following three heads: the ancient Hindu criminal law, Mohammedan criminal law, and English criminal law. If we talk about ancient Hindu criminal law, we see that the penal law of ancient communities was not the law of crimes. It was basically the law of wrongs. Because in those days, there was no such classification of wrongs as torts and crimes. There was not much difference in the nature of punishment for the modern varieties of wrongs. This view of the ancient penal law, though in case of almost all systems in the world, is not correct in the case of ancient Hindu criminal law. In the Hindu law, punishment for crime occupies a more prominent place than compensation for wrongs. Of the leading codes of ancient India, the Code of Manu is the complete digest dealing with law, religion, custom, and usage, then prevalent assault, battery, defamation, theft, robbery, gambling, and cheating, trespass were the main offences of that time, and the punishment prescribed from them was based on a scientific principles, and the highest prescribed punishment was the death sentence. The Hindu lawgivers did not expressly distinguish between civil wrong and crime. Still, the difference in penalties and procedures which they have prescribed indicates that they clearly realized in what way the criminal aspect of it differed from its civil respect. Heading towards Mohammedan criminal law. After the conquest of Islamics on India, the Mohammedan criminal law was introduced in the country, and Indian courts applied this law for administration of justice. Islamic law was imposed on Hindus conquered by Muslims, and it was originated from Quran and was considered as a divine law. All offences for punishment were classified under four broad principles. Qisas, that is, retaliation. They applied specially to offences against a person, willful killing and grave injury, and the injured party had the right to inflict like the injury on the offender. Another form was diyut, blood money. In certain cases where no retaliation was allowed, the injured party had the right to demand only blood money, known as diyut. Third principle was had, that was fixed penalty. In the case of had, the law prescribed and fixed the penalties of certain offences, for example, zina, illicit intercourse, drinking of a wine, theft, highway robbery, and accused a married woman. In case of theft, hands were cut off, and for dacoity and robbery, maximum punishment was death. The fourth principle for punishment was tazir, that was including discretionary punishment. When no punishment was prescribed, it was felt that it must be left to the discretion of judge to give punishment. Friends, Mohammedan criminal law suffered from many defects, as many of its provisions were not in conformity with good governance, natural justice, and common sense. The third part is English criminal law and the development of Indian Penal Code 1860. Let's talk about the history of it. When the East India Company took over the domain of India, the Mohammedan criminal law was in force. In 1765, the company acquired the Nizamat of Bengal, Orissa, and Bihar. The company had to then administer justice, for which in the beginning they adopted the policy of status quo. Gradually, defects of Mohammedan law were realized. Therefore, the first step towards removing those defects was taken by Warren Hastings, who tried to do away with the mutilation of dacoity. An effort was made to rationalize the punishment by making it proportionate with the crime. A regulation of year 1832 provided that in case of a trial for an offence under the regulations of non-Muslim could claim exemption from trial under the Mohammedan criminal law. But the changes so introduced were not applicable to all the presidencies. Most of them applied in Bengal alone. The result was that different rules prevailed in different presidencies, which in turn resulted in conflicts. Therefore, a commission was appointed to examine the conflicting features and necessary modifications. Later on, it was realized that a penal code was necessary. A penal code under the guidance of Governor Elphinstone was enacted, which was known as Elphinstone Code. It consisted of 41 sections only. In 1844, a separate code was drawn for the province of Punjab after its annexation. An All India legislature was created by the Charter Act of 1833. The office of law member in the Council of Governor General was created. Provision was also made for the appointment of a law commission. Earlier, that the first law commission was constituted in 1843 with Lord Macaulay, the then law minister, as its chairman. Sir Sri MacLeod, Anderson, and Millett were the other members. A draft was prepared by the Commission of a Penal Code for India, which was forwarded to the Governor General of India for consideration in 1837. Sir Barnes Peacock, Sir J.W. Colville, and many others revised it. After the completion of drafting in 1850, it was presented to the Legislative Council in 1856. Fortunately, the bill was passed on October 6, 1860. The Governor General assented it on the same date, and the Indian Penal Code came into operation on January 1, 1862. So friends, now you are very well aware of the story of Indian Penal Code coming into its existence. Let us start our journey to the knowledge of apparently well-codified law. In our next video, we will learn about the structure, extent, operation, and important amendments to the Indian Penal Code 1860. I hope you are excited to learn more. I would like to show my gratitude towards LicitElite for providing me the opportunity to utilize my skills for the greater good and teach the students through their YouTube channel. Thank you for listening patiently, and do not forget to like and share and subscribe us by hitting the bell icon.